Good morning, everyone. We'll just have another 5 minutes for all to enter, then we'll immediately start the session. Krishna, is everything ready now? Krishna, are you there?
Yes, sir, we are good to go.
Okay. Please switch. Have you switched on the recording?
Yes, sir, it is on. We request all the
No
participants
one
to
is.
take care of your
It's closed.
rights.
No one is.
All the participants are kindly requested to please mute their microphone. They will be allowed to speak whenever they are called upon. Good morning, one and all present here, respected dignitaries, eminent scholars, faculties from different institutions and research scholars, and my dear students. Today, we are highly privileged to gather here for enlightening ourselves on a very important and dynamic topic of intellectual property rights through a very important event, that is 7-day online faculty development program. Since human beings are known as rational animals, rationality is based on intellectuality, which is further can be categorized into innovations, creativity, and knowledge. However, preserving this intellectuality both as a right and also as a duty could be understood through the laws governing the sector of intellectual property rights. In academic institutions where knowledge originates, it is very much important to disseminate those laws that directly or indirectly deal with intellectual property rights. We, at present, are living at a phase of sustainable development where the empowerment of the future generation is the prime responsibility of all human beings, and the responsibility is even higher on the faculties. We therefore shall be entrusted with the knowledge, and for this objective and aim at hand, Department of Law, Central University of Karnataka has organized a prestigious 7-day online faculty development program with eminent resource persons from across the country that is highly expected to enlighten us so that we can further disseminate the information and knowledge gathered from such deliberations to our future generations. It is a prime time to acknowledge the presence of such dignitaries, and therefore we welcome our chief guest of honor, Professor Dr. Tushar Kanti Saha, sir, who has been the former Vice Chancellor of Starford International University, South Sudan. He has also served as Dean of the School of Law of Mount Kenya University and Director of the Law for the University of Asmara. He is a law graduate of the University of London and holds Masters in Economics and Law LLM from the University of Calcutta, standing first and second, respectively. He received his PhD in law from the University of Calcutta. Sir is also barrister at law of the Lincoln's Inn, London, and a Lady Edwina Mountbatten awardee, mentored by Lord Denning. Sir has served in the India Institute of Public Administration, Delhi, Hidayatullah National Law University, Raipur, etc. So visited more than 50 universities across 3 different continents. He has published worldwide and written 9 books. One of his notable achievements is the autobiography of Little No Indian. 100 countries, 100 wonders, who has just recently won the prestigious Golden Book Award 2025. We welcome you, sir. We are very much delighted to have you on this platform. Next, we have amongst us the guest of honor, Professor Dr. Yugal Kishore, sir, who is the former Vice Chancellor and Registrar Officiating of National Law University, Assam. He has also served as the former adjunct professor to KIT University, and also served as a professor and dean of ICFAI Law School, Dehradun. He has 36 years of teaching experience. He has produced 9 PhD scholars and 90 dissertations have been done under him. He has eminently been delivering on the different fields of law, including torts, criminal law, and then environmental law. He has mentored many students towards successful life. He has also conducted and organized many webinars, national seminars, faculty development programs, orientation programs, and he has also participated in many orientation programs, notable being including one organized by National Law School, India University, Bangalore. We also welcome you, sir, on this occasion. We also have a true leader who has guided all of us to achieve excellence in our professional life, and none other than the Honorable Vice Chancellor, Professor Dr. Battu Satyanarayan, sir, who is also the chair for this inaugural ceremony. We also welcome you from our heart, sir. The person without whose support I won't have the courage to organize this kind of events are Dr. Vasavraj Kavagadi, sir, who is the Dean School of Legal Jurisprudence Studies and as the head department of law. He has constantly supported
Your voice is not audible. Dr. Jayant, your voice is not audible.
we will start it.
Please do excuse me. So, we'd also like to welcome all our students, members from the organizing committee on this occasion. I'd also like to extend the most importantly my heartiest welcome to the participants who are 200 in numbers, but however, unfortunately, the UGC NET exam for the for our enlightenment, and also we need to take the grace of Almighty for the smooth conduct of this event. And for this purpose, I would like to call upon one of our students, Miss Priyanka Kumari, to please grace the occasion with Saraswati Bandana. Over to you, Priyanka.
या वीणा गणिदण्डे मण्डितकरा
Priyanka, please recheck your mic and connectivity.
या कुन्देन्दुतुषारिहारि धवला या शुभ्रवस्त्रावृता या वीणावरदण्डे मण्डितकरा या श्वेतपद्मासना या ब्रह्माच्युतशङ्करे प्रभृतिभिः देवी सदा वन्दिता या मां पातु सरस्वती भगवती निश्चयसजायापहा शुक्लां ब्रह्मविचारिषारि परेमा अत्यां जज्ञतापिनीं वीणापुस्तकधारिणीम् अभ्यदाम् जाग्यान्धकारापहाम् निश्चयस्फाटिकमालिकां विदधातिं पद्मासने संस्थितां वन्दे तां परमेश्वरीं भगवतीं बुद्धिप्रदां शारदाम्. Thank you.
Thank you, Priyanka, for making this occasion really special. One of the very inspiring leader of our institution, whose speech I had the opportunity on the occasion of Republic Day, and he was making us realize the responsibilities as academician, and it is a small attempt towards sustainable development. And I would like to welcome on this occasion our true leader that has always inspired us, Professor Dr. Bhattu Satyanarayan Sir, Honorable Vice Chancellor, as well as the chair of this inaugural ceremony, to grace this occasion with his wisdom and enlighten us. Over to you, sir.
So, good morning to everyone. Professor Tushar Kanti Shahaji, today the chief guest for this inaugural function. Professor Yugal Kishorji, the guest of honor, and the resource persons, the dear participants. I am congratulating the Department of Law, that is Central University of Karnataka, for organizing the 7-day online faculty development program on empowering innovation, advancing knowledge and practices in intellectual property rights. So this is the most appropriate topic which is required for all the faculty members, research scholars. These nowadays, whatever we do something that should be protected. So that is the intellectual property rights. Everyone know about this subject. So that is whatever we are carrying out, whatever research we do, whatever we innovate, that should be patentized. Then only we can protect it. If you are not aware about this law, so whatever you do, that go in waste. And because the world is moving in this direction only, so one has to encash whatever they do, the any kind of invention and innovation. And particularly in the university system, this is most essential. Now we are also established in our university the incubation center for creating an innovation atmosphere. So that is the students, even research scholars and teachers who have some kind of ideas, they can come and utilize the space and facility. They can do some innovative activities in the institution. And definitely that if anything that is in any innovative activity, if they do, definitely that will become a startup for the anyone, some kind of inputs. For that, again, we have to use this intellectual property rights. Then only, so whatever the scientists or research scholars or whoever having innovative ideas, they can also encash that one. Otherwise, people will not recognize us. Even if we have neglected many things and the European countries or USA, many things they are trying to take credit for the things which are available in India. We are using those since from ancestors' times. That is thousands of years ago. We are using everything like neem product, turmeric, everything. But we have not bothered about this one. Now people are coming and they are making it, and they are they are trying to taking credit. So therefore, it is our duty to make aware about this intellectual property rights, and whatever even from our ancient times, whatever we are using, that also we should go for patentization, and that is required. So therefore, this will definitely go a long way, and definitely, so this is a right time to organizing this program in the Central Vista Karnataka, and this will be useful for every participants who are participating in this 7-day program. I wish you all the best. Thank you.
Thank you, sir, for such an inspiration and enlightening us about the importance of having such events in the academic institutions. And we are hopeful that such expectations can be met throughout this event, at least to some extent. Now, I would like to invite one of the most inspiring academician, Professor Emeritus, and whose inspiration has always enlightened us, many of the scholars in this nation, Professor Dr. Tushar Kanti Sahasar, the chief guest of this inaugural ceremony, to kindly enlighten all the participants, including the organizing committee members. Over to you, sir. Sir, I think you are muted. Please, your audio is not coming, sir.
Is it coming?
Yes, sir. Now it is perfect, sir.
Okay, thank you so much. Good morning and welcome to this presentation. I am very happy and take immense pleasure in sharing my thoughts and ideas with you in a brief way possible. The topic is so innovative by itself, and I lay emphasis on the word innovation in my presentation, leading us to the sphere of artificial intelligence and its application, as well as legal protection and other consequences and ramifications in the field of our workplace, in life at large, and also in a global sphere, so to say. We all know this journey of intellectual property started in the modern phase from W2 TRIPS, which came into effect on 1st of January 1995. First thing, meaning of the very phrase intellectual property, simply state any ramifications, and the W2 TRIPS laid down the minimum standard of protection of IP. Then they have also incorporated what is called the dispute resolution body or solution body, DSB, and they have also instilled in the process the legal protection which is to be enforced by legislations in domestic sphere, by domestic legislations. To understand all these, we need to go back, jogging memory lane, especially in the field of copyright. It was that golden age of 18th century, and there are two landmark cases I will cite. One is the case of Donaldson versus Beckett, 1774. The other case is Miller versus Taylor, decided in 1769. Both these two cases are very relevant milestones because these two cases are preceded by the Statute of Anne, which was enacted in 1710. The first case arose in Miller versus Taylor, with regard to decided in 1769, heralded by a dispute with relation to the publication and copying by printing by another publisher based on the literary work, a kind of a series of poems published by the name The Seasons. The poet himself was dead. His name is James Thomson, whose life extended from 1700 to 1748. So, when the first case arose in Miller versus Taylor, the infringer of copyright pleaded that the author is already dead. As per the terms and conditions or the provisions of the Statute of Anne 1700, the copyright cannot subsist after the death of the author. That was the argument. But our legendary Lord Mansfield, whose history and achievements are well known throughout the world in the common law countries, he made a very good judgment. He said, copyright exists independent of the Statute of Anne. So he is dwelling on rather on common law other than the statute itself, which is an enacted law. The common law, it is unwritten law. It's a judgment law. So he says that the author is entitled to the fruits of his intellectual labor. But that case decided in 1769 was challenged in Donaldson versus Beckett, decided in 1774, 5 years later. Here is also a good legendary judge of the House of Lords, Lord Camden. He argued that the knowledge should be free. Now see the comparative scale of two judgments. One is asking for the protection of the intellectual labor, and other is that the knowledge should be in the free domain. Equally sound argument. But we know the time has changed, because if it is free, as in the USSR, you invent something or write something which is creative in nature or innovative, you are not entitled to any protection. You get a certificate that you have invented such and such, or you have written such and such. You will get only a certificate, but the property will belong to the state. That is another unfair thing. So there is no difference between butter and cooking oil. I had been arguing that in Soviet Russia, see, the property rights are not recognized, or the merit was not recognized. As a result, these innovators and writers of great dimensions, they suffered, or rather deprived, from their fruits of labor. So I used to argue that if you pay equally to a doctor and a miner, then the consequences are like this, that if you force the doctor to work in the mine, he will be able to do the job. But send the miner to the hospital to treat a disease, he will make havoc. He will make a havoc. So there has to be a difference. So merit has to be recognized. They are to be rewarded if we are to flourish and expand the horizon. So W2 TRIPS is a kind of new direction that has instilled recognition for at least nine items under the rubric of intellectual property rights. For example, copyright and related rights or neighboring rights, trademarks, patents, IC, then trade secrets plus undisclosed information, then GI or geographical indication, anti-competitive licenses. All these 9 items have been included under the TRIPS, and it was stipulating that all countries or signatories to this treaty will ensure minimum protection for all these intellectual properties. Having said that, we see even before this treaty was signed and came into force in 1995, there was a very landmark case in the United States of America, which made these property rights inclusive of the patent rights for inventions. And in Diamond versus Chakraborty 1980, the US Supreme Court has decided and made it abundantly clear, any human-made creation of organism is protectable in law, in spite of the fact that it may not be a living organism. And incidentally, we should remember or recapitulate this contribution by Professor Chakraborty in Diamond versus Chakraborty. His invention was artificial organism which will soak, or rather eliminate, the pollution or oil pollution on the sea water. They will consume and then it will clean up the pollution. So it was very innovative, creative, and very productive and beneficial to the human race as far as environmental protection is concerned. So one is integrated or protected, closely associated with each other. So that case also we have to keep in mind while discussing intellectual property rights, especially in the field of inventions. Now the new technology has intruded into our domain, which is, I call it, everybody knows it now, it is in the focus, artificial intelligence. For intelligence to flourish and contribute to expand the horizon of development, as well as uh, removing inefficiency, doing jobs very promptly, like in the legal field also. 1 hour lecture can be reduced to 7 minutes these days. The legal work in the law firms will be more efficient because most of the checking and review can be done by artificial intelligence, especially the citations. All the citations can be checked by the artificial intelligence. If that means that your time, valuable time, will be saved, and it will contribute to more efficiency both by the lawyer as well as profitability of the law firms, so to say. So impact is huge, and this impact can touch in the various fields, including the copyright in smell or in the service matters. You see. We know there is a landmark case called Kekhovo was a Lekome. It was about the smell of the particular perfume. And the court eventually decided that it will enjoy protection in law. The practical problem may arise in distinguishing different smells. Human nose can identify only a limited number of smells. So, should you engage dogs to identify these smells? That is a very, I think, crunchy question should hammer our mind, because a dog can identify as many as 5,000 different smells, you see. So application of our resources around us in the field of AI technology to confer and recognize copyrights or other rights, intellectual property rights, either it is smell, service, or other areas, we should keep in mind and then develop this idea into actions. And for that, business will flourish. Our government has also, the India government has also created a task force for this purpose. We have just seen the US president has declared that they are going to invest 500 to 1 trillion, 500 billion to 1 trillion in this sector. And we should not lag behind. Fortunately, our business model is also changing very fast. Already 706 different industries are working in the field of artificial intelligence. 706, including Tata Alexis, and just now Reliance Industries has entered, and so it is going to be very, very big. Having said so, how we should think in terms of legal protection. If necessary, we have to introduce new legislations. We have some piecemeal legislations dominating this area, like Digital Data Protection Act 2003, but there cannot be any comprehensive legislations because the technology is changing on daily basis. So we should devise some general principles. Based on that, we should try to capture all these new introductions in the field of knowledge and technology, and it is already incorporated in the W2 TRIPS, whereby they have under the industrial property, they have included the word innovation. The innovation includes innovations in the field of technology. Whatever kind of technology we think or imagine, it will be included. And through this route, we should always constantly revise the legislative measures to protect the intellectual property of the innovators, but at the same time, we should not forget to protect the privacy rights of the individuals. And it is heavily affecting the private domain also, this artificial intelligence. So I say, there is very recent case, the case name is Arijit Singh versus artificial intelligence tools, which includes a number of technology company involved in AI technology. Arijit Singh, you all know that he has just received the Padma Shri award from the government of India yesterday itself. So he lost the case he won in the Bombay High Court against AI tools, which preliminarily or mainly included Codable Ventures LLP, and this AI tools not only include this is the main company, but it has included many other like restaurants, those who play artificial music or view the voice of the singer without the endorsement or the consent of the artist. This is known as the voice cloning. Voice cloning was the issue in this case. It also leads us to what is known as the protection of the personality rights. The personality rights of the celebrities are in focus, and the court in this case based their judgment on two previous other cases. The one case is called Karan Johar versus IPA. It was in 2024. Then other case was in 2023, Anil Kapoor versus Simply Life India. These two cases are landmarks in the sense that they served as a basis or foundation for the latest judgment on Arijit Singh versus AI tools. The court has clarified that the celebrities are entitled to the rights to endorsement. So without endorsement, nobody can apply their voice or anything in the form of artificial intelligence to prepare any product for marketing purposes. It affects their personality rights. They are also saying that any kind of use or production or imitation of those personalities are also to be restrained. And restraining order was issued in that case, we already know, and it includes other aspects of personality rights like dilution, tarnishment, or blurring. So these things, in the absence of any specific law in the field of artificial intelligence, the court is extending protection through the route of the law of torts. So law of torts is one field, one subject area, which will open the door for all sorts of protection with regard to any distortion or abuse of names or likeness or the persona of the celebrity in general, but also ordinary people we can be included, but they will enjoy a little bit of better protection. And we already know it can affect not only the personality himself, but also his relative, friends, and other associates can be affected by this adverse advertisement or use or misuse of the personality of the celebrities. And this can lead to innovative application of newer type of injunctions which were already introduced in 2006, which is known as the super injunction. Super injunction was stalled for a time being. It originated in a case called Trafigura, decided in 2006, relating to the dumping of poisonous substances on the seaside, whereby rag pickers, small children, went for picking their things, got poisoned by inhalation and died. It was a huge scandal, but the dumping site is not in the focus. The focus was on the company originated from London, who were sending them to third world countries for dumping purposes. So they got an injunction, which is come to be known as super injunction, which will not allow the media to publish that there is an existence of super injunction. If they publish, they will incur the wrath of the court and they will be found guilty on the contempt of court issue. That was, in a way, it was unfair for the media expression of the freedom of speech, but to limited scale, it has been still retained in England. There were subsequent cases where it was not approved as such, but I see there is a regeneration of super injunction in this field. It is going to come back for the protection of the celebrities, especially speaking, and also in general. So this is all that I have to say at this point of time. I thank you all for your patient hearing. Thank you very much.
Thank you, sir. You have beautifully connected global aspects of intellectual property rights and discussed the various necessities of the laws, aspects of the laws through case laws decided. And through this, you have beautifully explained in a very short time topic that has a very wide scope. We are highly delighted through your
Thank
deliberation,
you, sir.
and I hope and I expect that our participants have also been enlightened. They might have got the exact introduction that how dynamic this topic is. Thank you, sir, once again, sir.
Thank you so
Now,
much too.
yes, sir. Welcome, sir. Now, I would like to invite Professor Dr. Yugal Kishore, sir, a guest of honor for this inaugural ceremony, to kindly enlighten us on the theme of the FDP, sir. Over to you, sir.
Okay. Good morning to one and all. Am I audible?
Yes, sir. You're audible, sir.
Means my voice is clear. Otherwise, I can.
Yes, yes, sir.
Okay.
Yes.
Thank you very much. Well, thank you very much. So, respected Professor Dr. B. Satyanarayana, sir, Honorable VC of Central University, Karnataka, Chief Guest of the inaugural ceremony, Professor Dr. T.K. Shah Sahab, former VC, Stanford International University, to whom we have just heard, and members of the organizing committee of the 7 days FDP on empowering innovation, advancing knowledge and practices in intellectual property rights, the faculty and staff of the university, delegates and participants from different parts of the world, invitees, dear students, and ladies and gentlemen. I congratulate at the outset university authorities for organizing this 7 days FDP on a topic which is very important and relevant, because this can make this particular topic can make India a global innovation leader and thereby superpower in future. So I take this opportunity to thank my from the core of my heart the authorities of the university, law faculty, and especially Professor Jayant Baruaji for inviting me to this FDP and providing me with an opportunity to speak a few words. Here in this particular deliberation, I will be speaking about first the status of India in the world intellectual property right indicators 2024. Then I'll be talking about the role of faculty of the university in making India a global innovation leader. Under this head, under the second head, I will be talking about development of the culture of the innovation in the higher education institutions, and then the second, use of IPR instruments in advancing knowledge and practices of innovation culture. So, first of all, the status of India in the I will be talking about. So, the World Intellectual Property Right Organization (WIPO) has published on November 12, 2024, the World Intellectual Property Indicators 2024, mentioning the global trends of intellectual property filing. Therein, it has mentioned that India has secured a place in global top 10 for all the three major intellectual property rights that is patent, trademark, and industrial design. With regards to patent, India has recorded a fastest growth in this era, with 64,480 applications being made. And the best thing is that more than half of it has been made by the Indian resident. And therein, and thereby India has become in the 6th position as far as the filing of patent is concerned. And India has increased up to 150% from 2022 to 2023 in the grant of the patent. So we can see that how the India is developing very fast with regards to the patent filing. Similarly, with regards to, if you look at the industrial design, then there has been a 36.4% growth in the filing of the patents. In the filing of the industrial design. And these industrial designs were mainly on the basis of the textile and accessories, tools and machines, health and cosmetics. So, and here again, around 90% of the applications were made by the Indian residents. With regards to the trademark, the growth has been 6.1% from 2022 to 2023. But the 90% of the filing of the trademark has been by the Indian residents. And if you look at the status of the trademark, so Trademark Office of India holds the 2nd largest number of trademarks with 32 million trademarks in force. And thereby, India has become a very strong country with regards to global branding. Now, in this way, we see that because of the government initiatives of the intellectual property right policy, National Intellectual Property Awareness Vision, which we call as NIPAM, and the Kalam Program for Intellectual Property Literacy and Awareness campaign, which we call as Kapila, we have done a great work. But of course, in order to become a global leader in innovation and intellectual property right, India has to go a long way. And for that, this particular seminar, this particular 7 days FDP can be very important, because in this 7 days FDP, we will be talking about the role of teachers who can inculcate the culture of the innovation among the students. And these students, in due course of time, can file a number of patents, and thereby and intellectual property rights, other aspects. Thereby, India can become a global hub. So now I'll be talking about the role of the teachers in developing the innovation culture in India. So here, if you look at the faculty, those who are here and those who are not here also, they have got a great role to play. So what you can do is, you see, these days, the type of education which we are providing to the student basing on the lecture method is not sufficient. The reason is that their aspirations are different. They have got so many things on the network by which they can get knowledge, they can get information. So information and knowledge is available plenty on the network. But side by side, they are having a lot of entertainment material also. So therefore, they are more lured towards the entertainment than the lecture method of class. And we have found, many of you must have experienced, that our students, they do not show that type of inclination and dedication and sincerity in the class. So therefore, the time is that we faculty have to cultivate ourselves in such a way that we are capable of providing them with different type of culture of innovation. So that can be done by providing them the personal touch. So the faculty here, I request them that first of all, they should look into the 4 C's of innovation and see that how it can be applied to the class of the student. So the 4 C's of innovation are context, culture, capability, and collaboration. So these are the 4 things which the faculty has to look into, and keeping that thing in mind, he has to work for the culture of innovation. Further, there are 7 C's also of innovation which the teacher can, which the faculty can look into, that he has to cultivate, he has to inculcate in the students. They are curiosity. So development of curiosity is very important. Then connections, then courage. Encouragement is very important. Then commitment, then creativity, then collaboration, and then celebration. So if these 4 C's and 7 C's are kept in mind by the faculty while developing the culture of innovation, then I think the situation can be much more improved. And here there are some other role which faculties can play. That is, they can inculcate in themselves the leadership qualities. That means they can inculcate in them effective communication skill, which is also very, very important. Then thereafter, they can have a collaboration spirit. That is also very, very important. So if we look into that, therefore, if we go for that, then we will find that the things can be done in a better way. Now, faculty has to set goals and provide the students with delegation, with transparency, with accountability, with regards to innovation culture, so that a trust is created among the student. So a student can feel, yes, we can also do something. You see, I understand, it is my personal feeling of around 38 years of teaching experience, that if we create a trust in the students, we can do a number of things which are very much possible for us to do. So here, if we look at, we have to first of all create that trust, and then we should give them utmost autonomy so that they can develop the inspiration, the confidence, the freedom of analytical and critical thinking in them, so that they can develop new type of solutions, new type of thinking, new type of ideas, which can be further developed into intellectual property right. So here, I would like to request my faculty that now a lot of material is available on the online. So instead of teaching the whole course, teaching every bit of the section and then case laws, we should go for providing them literature from the online. So the flipped class can be very handy. So you can have flip class, and therein you can provide them with materials which are available on the online and give it to them, or you can yourself produce those material and hand it over to a student and say that you read it and come forward for the class. And the class, most of the time of the class should be devoted to discussions, to cultivating of new ideas, how to solve the problems. And if it is done in a proper way, then I can understand the students will be capable of developing that culture. Further, my faculty, of course, I understand I'm talking very high. My expectations of the faculty have become very high. But then my faculty can have a different type of collaborations. Different type of, they can invite, like Jayant has invited our Shah Sahab here, the experts in the field. So these experts who are there in the field of that particular type of subject, when they come therein, the great professionals, they come therein and they discuss with them and they talk about innovation, what can be done in future. Then students can be very well connected with them in future. So in that case, students will be certainly be more interested. My voice is clear, Jayant?
Yes, sir. Yes, sir.
My voice is clear. Okay. So a student will be certainly more interested in the development of innovation culture. I tell you, these days students, they are not interested in the class. They want easy money. They want easy fame. They want easy reputation. They want everything easy. So if such type of discussions are being created in which they come to know that by this innovation, I will be known through the worldwide as through my intellectual property right, and I can earn a lot of money through the intellectual property right regime. Certainly, they will be interested. And but of course, side by side, for working in this field, one thing will be very important, that many times we need funds for doing certain job of innovation. So therefore, my dear faculty, you will be thinking that I am asking so much from you, but then you can facilitate the students with the funding. You can just inform them that these are the bodies who can fund, who can provide you grant, who can provide you resources, who can work with you for the innovation. So in this way, of course, I will be just requesting you. I cannot talk everything about it here because time is very short. But Mr. Aithal, I'll tell you the name of the person who has written a number of articles on it. So that is Aithal, A-I-T-H-A-L. So Mr. Aithal, husband and wife, his name is Mr. P.S. Aithal and Subra Jyoti Aithal. So they have worked on very much on this particular aspect, on culture development, on use of IPR as in pedagogy, use of IPR in the analysis. So they have worked on that. So you can go through the literature. It is available on Google Scholar, so that you can work in future. But of course, now the second part I will be talking about, which I told you, that was with regards to I was talking about that the type of pedagogy you should apply. Now, here, the time has come that instead of going for simply the pedagogy which we have been applying, that is lecture method, we have to go for applying the experiential learning method. That is what I was talking to you earlier, that much of the time of the student should be there for learning by doing. So if they learn by doing, you can take them, it is something like practicals. Supposing you are working on the field or in the field of intellectual property right, then how intellectual property right application can be filed, intellectual property filing of that particular application, how to identify that it is innovation, it has novelty or not, how to get it, how it can be managed in a larger way, so that intellectual property right can be provided. And it is not only in intellectual property right. I tell you, even supposing you are teaching contract also. I have taught contract for a long number of years, but I have never gone for contract drafting. So what I feel that now the time has come, because now literature is available, things are available before the hand of the students. Now we have to cultivate in them the skill. So now you should start with discussing with the basic principles, and then further contract drafting. How the contract is drafted, so that once they go for practice, they will be knowing how the contract is drafted, what are the important things therein, and how we can go ahead with. So these things are very important, which we have to cultivate in us. In our faculty also, I'm also a faculty like you, so we have to cultivate. Now, because my time is almost over, so I will be just talking in 2 minutes. The third aspect which I was talking about, that using the patent or industrial design or trademark analysis as to help the culture of innovation. So I'll be taking here the patent first. Of course, I'll talk about only patent because time is very short. Otherwise, I could have discussed one by one. So supposing we take patent here to go ahead with. So patent, there are different sources, database from where patent details and documents can be sorted online. Likewise, United States Patent and Trademark Office, European Union Patent Office, Google Patent Office, or likewise other countries are also having. So from there you can get the online get the document of the patent. From there you start discussing with the student. Then how the patent is granted, what is novelty, how things can be done, and then in a long way the patent can be analyzed with the students with these important parameters. So I read these parameters: analysis of the patent characteristics and claims, patent opportunity analysis, patent performance analysis, patent innovation analysis, patent technology analysis, patent and value analysis. So likewise, other analyses are also there, but these are the important analysis which I'm talking about. So if you systematically work on this patent analysis with the student will come to know of that patent and trademark or whatever it is. Student will certainly come to know of that how he can be granted the patent, or how he has to cultivate this innovation. And innovation is of such a novelty that patent can be taken, or copyright can be taken, as our Sahasha was saying, talking about copyright. So copyright can be taken, our trademark can be taken, our industrial design can be taken. So likewise, whatever it is, there are a number of things. So if we can do, if you work in that way, even supposing you are there in the class teaching LLB students of the 5 years, you can take the whole of the case law on a subject. And with that, all important aspect you can extract and then discuss with the students that this was the point, this has been done. So in this way, we can cultivate the skills in the student, and these skills will help them very much in the when they become professional. And side by side, what I was talking about here, patent and other things, if that has been done, then students will develop certainly the culture of innovation. They will be empowered with the culture of innovation. And if that is done in a systematic way, then I'm sure that number of intellectual property filings will be there in India, and India will become the hub and the most, a country which has filed maximum number of intellectual property rights regime, and therefore we will become not only the superpower, but first of all we will become the leader in intellectual property innovation, leader in innovation, and then we will become a superpower. So with this, I'm very much thankful to you for listening, for patient hearing, and I request that you go for you are all most of the you are interested in intellectual property right. So please go through with those articles so that whatever I have left you can read from there. Thank you very much. Jai Hind.
Thank you, sir. Thank you, sir. You have very broadly dealt in detail art and science of teaching methodology for dealing with intellectual property rights. It is very nice on our part to learn from you. Hope we could have more time, but unfortunately the next session has already started. So now, since a very beautiful session will have to come to an end, since every beginning has an end. So for formalities for this inaugural ceremony, I would request one of my senior colleague, Dr. Anand sir, who has always guided me, to please extend the formal vote of thanks and to formally thank the August gathering. Over to you, sir.
Thank you, Dr. Jayanta. Indeed, it's a great pleasure to be part of this 7-day online faculty development program on empowering innovation, advancing knowledge, and practice in intellectual property rights. First, I would like to extend my warm thanks and gratitude to today's two chief guests who are known in their own field. One, Professor Dr. Tushar Kant Saha, former Vice Chancellor, Stanford International University, South Sudan, who very aptly pointed out how the intellectual property playing important role and bringing new business model. The innovation like artificial intelligence, voice cloning, and he has discussed with lot of landmark cases. Sir, indeed it's very nice to hear from your side. I, on behalf of Central University of Karnataka Department of Law and the whole organizing committee, extend my heartfelt gratitude to you, sir. Thank you, sir. The other speaker, Professor Dr. Yugal Kishore, former professor, former Vice Chancellor and Registrar, National Law University, Assam. Indeed, he gave very in-depth information regarding the status of India in IPR, intellectual property rights, role of university, higher education, and teachers to make India a global leader in innovation, and more particularly, he spoke on the role of teacher in inculcating culture of innovation in students. Sir, indeed, it was a very, very informative and insightful talk from your end, sir. Thank you. I once again, convey my gratitude on behalf of Central University of Karnataka Department of Law and on behalf of all my colleagues, the head of the department, Dr. Basavaraj Kupkadi, and my other colleagues. I extend my whole heart thankful to you, sir. And in absentia, I would like to thank Professor Battu Satyanarayan sir for the person who is instrumental and guiding force behind all such activities. I thank Professor Battu Satyanarayan sir, the Honorable Vice Chancellor, Central University of Karnataka, and all the authorities for providing and making this event a successful one, that is the inaugural session. Thank you once again, all the delegates, participants, students, research scholars, and all the teachers. Thank you. Over to Jayanta.
Thank you, sir, for such a nice extension of vote of thanks. Now, with this, we come to the end of the first inaugural ceremony of the 7-day online FDP on IPR. And I would request Mr.